Namaskar. In this video series on the refresher manual for execution matters for the staff at district courts at Punjab, Haryana and UT Chandigarh, today we shall be looking into frequently asked questions as asked by the process serving agencies across Punjab, Haryana and UT Chandigarh at the time of preparing this manual for them. So without further ado, let me take you to chapter 6 of the said manual, which speaks with regard to the frequently asked questions. Now the first question is whether there is a time limit to conclude the execution process. Yes, the Honorable Supreme Court in Rahul S. Shah versus Jinendra Kumar Gandhi, 2021, Volume 6, Supreme Court Cases 418, has directed the executing court to conclude the execution cases within a period of 6 months and in case of any extraordinary circumstances for delay to record the reasons for the same. What is the recourse available when the address of the respondent or judgment debtor is incomplete or incorrect? Order 21, Rule 10 CPC provides that a holder of decree who desires to get it executed has to apply to the court. Order 21, Rule 11 CPC deals with the application. Under Subrule 2 of the same rule in written application, the requisite particulars are required to be submitted by the applicant or decree holder, duly verified, including the name of the person against whom execution is sought, which includes complete and correct name along with complete and correct address. In the same provision, the applicant or decree holder is required to state the mode in which he is seeking the assistance of the court in execution of the decree. Under Order 21, Rule 17 CPC, on receiving such an application for execution of the decree, it is a duty of the court to scrutinize to ascertain whether the said particulars have been provided, and if not provided, to allow the same to be provided then and there only. Otherwise, to grant a period of reasonable short time to provide the same. Under Subrule 1A of the said Rule 17 CPC, in case the applicant or decree holder who has sought the assistance of the court in execution of the decree fails to provide the complete and correct particulars regarding the same, the name and address of the person against whom the execution of the decree is sought, the court is to reject such application. As per Volume 1, Chapter 12, Part E, Rule 13 of Rules and Orders, dealing with the procedure of application for execution, if the applicant or decree holder does not take the necessary steps to prosecute his application, which includes providing of complete and correct name and address of the party against whom the execution is sought, the execution case is to be dismissed. Under Order 21, Rule 24 CPC, the court is expected to issue process for execution after complying with the requisite requirements, Rules 11 to 14, by the applicant or decree holder, which includes providing of complete and correct name and address of the person against whom execution of decree is sought. Under Order 21, Rule 25 CPC, the process serving official has to make an endorsement on the process as to the delay on which it was executed and as to the manner in which it was executed and the reasons for non-execution or delay, if any, in the execution of the process. Under Subrule 2 of the said Rule 25, the court has to satisfy itself as to the said report of the process serving official in the endorsement on the process. Therefore, as and when process serving official finds the process containing incomplete or incorrect name and address of the person against whom a process is being issued, he is to make a report in the endorsement to be submitted by him under the said Rule 25. It is expected from the executing court or an official entrusted with the process of preparation of the process, that is Elmad, to ensure that the complete name and address is provided by the party at the time of preparing the process to be issued, otherwise to bring it to the notice of the executing court. Volume 1, Chapter 12, Part H, Rule 4 of Rules and Orders dealing with attachment provides that all executing courts are required to seek a note on the warrant of attachment or file to be recorded by the reader of the court that the specific formalities required by the law to have been actually complied with. The presiding officer of the executing court are required to carefully scrutinize such note and initial it in token of its scrutinizing before putting their signature on any such process. The same procedure can be applied for ensuring the sending of any other process with complete or correct name and address of the person against whom a process is being issued. What is the recourse available when a warrant of attachment of property cannot be executed for want of proof of ownership? The answer to that question is that the applicant or decree holder seeks the assistance of the court in execution of decree by moving a written application with requisite particulars under Order 21, Rule 11, Sub-Rule 2 CPC. Under Order 21, Rule 12 CPC, in case attachment of movable property is sought, which is not in the judgment debtor's possession, the applicant or decree holder is required to annex with his application an inventory of the property to be attached containing a reasonable, accurate description of the same. Order 21, Rule 13 CPC for seeking an attachment of the immovable property. The requisite particulars as to the description of the property, boundary numbers and record, if any, share of the judgment debtor, etc., is to be submitted in the application. Order 21, Rule 14 CPC, the court may require the applicant or decree holder to provide the certified extract from the register of the office of the collector as to the said land. Under Order 21, Rule 11, Sub-Rule 2 CPC, every application submitted in writing for seeking the assistance of the court in execution of the decree is to be signed and verified by the applicant. It has been seen that the precious time of the executing court gets wasted in case of warrant of attachment of property are issued and it gets discovered that the said property is either not owned by the judgment debtor or is not capable of attachment under law. In order to successfully conclude an execution case within the mandatory period of 6 months, it would be required at the part of the executing court and the official entrusted with the process of preparation, that is helmet, to ensure the obtaining of the copy of the document as to the ownership where available of the judgment debtor and to see as to whether the property sought to be attached is capable of attachment under law or not as provided under Section 60 CPC. Volume 1, Chapter 12, Part H, Rule 4 of Rules and Orders dealing with attachment provides that all executing courts are required to seek a note on the warrant of attachment or file to be recorded by the reader of the court that the specific formalities required by the law, including the ownership proof where available, otherwise an affidavit in support of the application and property being capable of attachment under law, have been actually complied with. The presiding officers of the executing courts are required to carefully scrutinize such note and initial it in token of its scrutiny before putting their signatures on any such process, that is warrant of attachment of the property. What is the remedy available if the concerned police station does not provide the requisite police assistance in execution of process by the court? The procedure to be followed for rendering police assistance in execution of the process is provided in Volume 4, Chapter 7, Part J of Rules and Orders dealing with the police assistance. As per the same, the police assistance is to be sought from the head of the police department, commissioner of police or senior superintendent of police or superintendent of police through learned district judge or the learned civil judge senior division of the sessions division. This is a little time consuming formality. Honorable Supreme Court in Rahul S. Shah versus Janendra Kumar Gandhi 2021 Volume 6 Supreme Court Cases 418 has passed certain directions, one of which is that the executing court can direct the concerned police station to provide the requisite police assistance to the process serving official of the court to facilitate the same. This means that now an executing court can directly write to the station house officer of police station for providing the police assistance. The Honorable Supreme Court has further directed that if station house officer of the said police station does not discharge his duties as per the directions of the executing court, then to take stringent legal action required in the facts and circumstances of the case against such officer. The police assistance includes the requisite, meaningful and substantial police assistance as per the facts and circumstances of the case. In case any difficulty is found in discharge of his duties by the concerned station house officer of the said police station, the executing court should always take the requisite stringent legal action, which includes proceeding for commission of offence under Chapter 10 of Indian Penal Code, dealing with the contempt of lawful authority of public servants, especially Section 186 IPC for obstructing public servant in discharge of public functions, and Section 187 for omission to assist public servant when bound by law to give assistance. What is the procedure to be followed by execution of process against government officers or official? The bailiff entrusted with the process against the government officer or official is to execute it as per the directions contained in the process. In case of any resistance or non-cooperation in the same, it is to be reported in the endorsement required to be submitted under Order 21, Rule 25 CPC by the process serving official. It is therefore incumbent upon the executing court to take suitable legal action in the matter against the government officer or official who has resisted the process of the court or who has not cooperated in the service of the process, which includes proceeding for commission of an offence under Chapter 10 of Indian Penal Code, dealing with the contempt of lawful authority of public servants, especially Section 173 IPC for preventing service of summons, including lawful affixing to any place of any such summons or other proceeding, or preventing publication thereof, Section 180 CPC for refusing to sign statement, Section 186 IPC for obstructing public servant in discharge of public functions, and Section 187 IPC for omission to assist public servant when bound by law to give assistance, as the case may be. It is expected that name and particulars in the process should be complete and correct before it being entrusted to the process serving official for its execution, the duty of the Elmad and reader of the executing court. How can the custody superdari of the attached movable property be dealt with? Under Order 21, Rule 43A CPC, where the movable property is attached and it is of such a nature that it cannot be conveniently removed, then bailiff at the instance of the judgment debtor or at the instance of the decree holder or at the instance of any other person claiming interest in such property can leave it in village or the place where it has been kept in the custody of any respectable person who will be custodian and will be liable to produce it in the same condition as per the orders of the court. Under Order 21, Rule 43 CPC, if movable property is capable of conveniently removed other than agricultural produce and is in possession of the judgment debtor, such property is required to be seized by the bailiff and to be kept in his own custody or in the custody of one of his subordinates. Therefore, the property which is removable is not to be left in the custody of any respectable person, rather is to be taken in his custody by the bailiff, thereafter to be deposited in the civil malkhana through nazir. It is only in case of a property which cannot be conveniently removed that the custody of the property is to be given to any person as deemed fit by bailiff. There is no specific provision for entrusting the duty to arrange the respectable person to obtain the custody of such a property. However, the executing court, keeping in view the facts and circumstances of the case, is required to ask the decree holder or applicant to arrange any such respectable person or to obtain its custody himself as he is seeking the assistance exercising inherent powers under Section 151 CPC in case difficulty is faced in non-availability of any such person to whom to obtain custody. What are the options available in case the requisite cooperation is not received from the chowkidars, municipal councillors in identifying the person against whom the process is issued and witnessing any execution of process? In villages, there is normally a chowkidar appointed under the Punjab Chowkidara rules and headman or lambardar appointed under the Punjab land revenue rules to perform certain duties, which also includes in assisting the process server of an executing court to identify a person and witness the process. In case a report under Rule 25, Order 21, CPC received from the process server regarding non-providing of the requisite assistance, then the executing court is expected to proceed against the chowkidar or headman or lambardar, not only under the provisions of law, including Section 187 of Indian Penal Code, omission to assist a public servant when bound by law to give assistance, but also by writing to the Deputy Commissioner to dismiss such a chowkidar for his misconduct and neglect of duty under Rule 11 of the Punjab Chowkidara rules and headman or lambardar under Rule 16 of the Punjab Land Revenue rules. Volume 4, Chapter 7, Part G, Rule 1 of Rules and Orders dealing with the assistance by village officers in process serving provides the issuance of directions by the financial commissioners to lambardars to assist the process servers in serving process and subordinate courts to bring to the notice of the collectors case of willful negligence of duty in this direction on the part of the lambardars and not to hesitate in moving the Honorable High Court through the proper channel if the matters do not improve even then. Volume 4, Chapter 7, Part G, Rule 2 of the Rules and Orders dealing with assistance by village officers in process serving further provides that in order to reduce the possibility of false reports being made on the notices of sale, it should be attested by a lambardar and wherever possible also by the village patwari or schoolmaster. Otherwise, in villages, assistance can be sought from any panch or sarpanch of the Gram Panchayat, the elected representatives. Otherwise, under Order 5, Rule 17 CPC, wording is if any person is available for identifying the person and witnessing the process. That means in case nobody comes forward to identify a person or to witness a process, the process serving official can execute the process and to submit such facts in his report to be endorsed on the back of the process under Order 21, Rule 25 CPC. Similarly, if in an urban area, a municipal councillor does not come forward to identify a person or to witness a process, an ex-municipal councillor can be joined or any other respectable person of the area can be joined in identifying a person or witnessing the process. In case none is available, the process serving official is to report in the endorsement on the back of the process under Order 21, Rule 25 CPC. The executing court can always direct the process serving official to take the assistance of the decree holder or applicant for service of process where no chowkidar or panch or sarpanch of village is available to identify the subject matter of the process. Under Order 21, Rule 11, Sub-Rule 2 CPC, the decree holder or applicant is basically seeking assistance of the court in execution process. Section 151 of the CPC provides inherent powers to court to pass any order necessary for the ends of justice. Otherwise, the executing court can proceed in accordance with law, which includes proceeding for commission of an offence under Chapter 10 of Indian Penal Code dealing with contempt of lawful authority of public servants, especially Section 176 for omission to give notice or information to public servant by person legally bound to give it, Section 186 IPC for obstructing public servant in discharge of public functions, and Section 187 IPC for omission to assist public servant when bound by law to give assistance as the case may be. What is the recourse available when villagers are reluctant to sign the reports as witnesses after the refusal from the party concerned? Now, answer to the question is given as Order 21, Rule 25 CPC requires the making of endorsement on the process issued by the court as to the day on which it was executed and the manner in which it was executed. If no villager comes forward to witness the report, the process server can always in his endorsement mention the same, and he being a public official entrusted with the process of execution should be believed. Otherwise, the executing court can proceed in accordance with law, which includes proceeding for commission of an offence under Chapter 10 of Indian Penal Code, dealing with contempt or lawful authority of public servants, especially Section 180 IPC for refusing to sign statement and Section 187 IPC for omission to assist public servant when bound by law to give assistance as the case may be. The next question is that how to deal with a situation where the women of the village neither opens the door nor receive the process. Now, answer to the question is that in case women in village does not open the door for receiving the process. Such a process can be affixed on the outer door with an endorsement to that effect. Under Order 5, Rule 15 CPC, due to non-availability of defendant, service can be effected through any adult member of the family, whether male or female, who is residing with him. Under Order 5, Rule 16 CPC, person served or through served is required to put signatures as an acknowledgement of service endorsed on the original summons. Under Order 5, Rule 17 CPC, on refusal to accept service or on non-availability of any person, the serving officer is to shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the person to be served ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it was issued with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. However, Volume 4, Chapter 7, Part B, Clause A, Mode of Service, Rule 1 of Rules and Orders dealing with service of process requires that every attempt should be made to effect personal service in the first instance, and failing that, service on an agent or a member of the family, and further that the process server should go again and again for this purpose. Otherwise, the executing court can proceed in accordance with law, which includes proceeding for commission of an offence under Chapter 10 of Indian Penal Code, dealing with contempt of lawful authority of public servant, especially Section 173 IPC for preventing service of summons, including lawful affixing to any place of any such summons or other proceedings, or preventing publication thereof. Section 186 IPC for obstructing public servant in discharge of public functions, and Section 187 IPC for omission to assist public servant when bound by law to give assistance as the case may be. What is to be done when very short dates are given to execute the process? Now, the answer to the question is that the Supreme Court in Rahul S. Shah versus Jinendra Kumar Gandhi and others 2021 Volume 6 Supreme Court Cases 418 has directed the courts to conclude the execution cases within a period of 6 months. Therefore, the dates are required to be given accordingly, and long dates are otherwise not justifiable. Further, a reasonable time must be given requiring the facts and circumstances to execute the process. Otherwise, it will be a wastage of time. Hence, process is to be executed within the time frame given by the court. Question number 11 is that in the case of proclamation Munadi, mostly drummers are not available to convey the contents of the proclamation to the general public by rendering their service. How to execute the process in the absence of the drummers? Now, answer to the question is that the applicant or decree holder can always be asked by the court to arrange for a drummer for execution of a process through Munadi. At every station, list of drummers with their contact numbers can always be maintained by the process serving agency, and in case of non-availability of one of the drummer, the other drummer can be asked to join the execution of the process. Whether the phone number of the addressee should be mentioned on the summons so that the addressee may be contacted in case he or she is not found present at the given address. Now, answer to the question is that service through phone is not an accepted mode. Once an address has been given, the applicant or decree holder has to ensure that it is complete and correct and can always be directed to assist the process server to locate the said address. So this is some part of the frequently asked questions. In our next video, we shall be looking into some more questions which have been frequently asked by the district staff pertaining to the execution of the summons or warrants or processes. Till then, namaskar.